first off, I should welcome everybody to the show. Today's show is about um, the Statute of Westminster. And just turn the volume down just a smidgen. And we're going to try and get into a little bit of a deep dive over it. Now, this is supposed to be a structured debate. We have a formula that we wanted to go through. Tim has been added to it. Tim has been given the formula we're going to go with. Marilyn was given the formula for it. And just before the show, Tim, just so you're not surprised, right out the window. I have some interesting observations that have just come apparent in my little world. So first thing I'd like to do is I'm going to add Tim to the stream, and I'm going to add Marilyn to the stream. Marilyn. First off, welcome both of you. Marilyn's left she'll be back. Tim, can you give our viewers a little bit of a background on who you are?
Yeah, for sure. I am a living man, a human being who's very interested in historic research and facts and learning about all kinds of conspiracies that turn out to be true after you do a lot of digging and reading. So I'm just a human being with a very curious mind, and with my engineering background, I like to be very precise. I like to look at real facts and principles and stuff that has been proven and not just hearsay. And that's why I dig. I dig until I find the source, and then I read the source, and then I try to connect dots. I don't make a claim that I know everything. Yeah, that's me.
When you started off, how long have you been on this journey about the Statute of Westminster?
Oh, I would say probably 6, 7 years.
Wow. Okay.
Yeah, not as long as Doug Force, who we greatly miss. He's been at it for much longer than that, and he paved the road for a lot of us. But yeah, 6 to 7 years ago, that's when I started stumbling upon this, and it caught my attention right away, piqued my interest, and I started reading.
Now, people may not know Doug Force, but you collaborated on a project with him that gained some awareness, I guess, of pretty much around the world. Can you give our viewers a little bit about that project?
Yep, for sure. That's the documentary film called Canada the Illusion. And after talking to Doug many times on the phone about the historic documents and how intricate and some of them like difficult and hidden the information, how I thought, well, how can we get that to the masses? And at the time, I made a presentation for a homeschooling group. And while I made the presentation, I saw, well, wait a minute, you can export a presentation to a movie. And then Doug told me that he had planned for several years to actually make a movie. And I started putting the movie together. Doug helped me ensure that the facts are stated correctly, in a good order, that it's presented nicely. And yeah, we collaborated on that film together. He put a lot of work into it. I put a lot of hours into it. And it definitely has grabbed the attention of a lot of people out there, has caused discussion, which is good. Again, we're not claiming that everything in that film is what it is, and you should take our words for it. We want people to go and read these documents, and if you got something to bring to the table to prove us wrong on what we found, please bring it. But it really gets the conversation going, and that's what's important.
We are waiting for Marilyn to rejoin us. It's not a problem on her end. It's actually a problem on ours. And there we go. We just got Marilyn added to the stream. We will have her do her same introduction here just momentarily. Let Marilyn get settled in just for a second. And there we go. Welcome, Marilyn.
Thank you. It's nice to be here. Appreciate that.
Marilyn, can you tell our viewers a little bit about your background, please?
Certainly, I'm a Western Alberta lady and became a lawyer when I was 40 years old. So I've had decades at the business. I'm currently more of a businesswoman. So, but I became interested in Alberta becoming its own nation in about the year 2020. There had been a lot of communication about Alberta becoming its own nation in about 2017. So I did the research to see whether that was even possible, even though I was very firmly rooted as a Canadian supporter. I found out in 2017 that it was doable. So, it could be talked about, but I was not interested in promoting it. Because the path was difficult. And as I said before, I was very much loyal to Canada. In November 2019, by that time, I began to understand the logic of Alberta leaving Canada. And I spoke at a Freedom Talk conference and I explained to the participants, there are about 200 people there in Calgary, the process of how Alberta could leave Canada. But I also said, I don't believe it will happen. And this was not kind. I said, because I do not believe that people in Alberta have the wherewithal to put the necessary load on their shoulders.
Oh, that's a pretty big deal. Why that?
Because as I looked around and had gotten to know the separatist leaders, they didn't understand the practical path. They weren't even talking about it. They were just talking about who could make the biggest noise in front of a microphone.
Fair. Good. Thank you very much.
But this is just before COVID, I began to see the communization of Canada more and more. And I decided that Canada was failing. Whether I could make a difference or not, I did not know, but I had to do my part. And I made it public that I personally believe that Alberta should leave Canada. Under the cover of COVID, the compunction came to me that I had to explain it to the people. So this is a confession for the first time publicly. I went to 13 different homes across Alberta and gave the how-to presentation of how Alberta could leave Canada. That's how I met Bob Lyon. In the dead of winter, I traveled up to his place in Peace River and got back at 4 a.m. And I took a lot of heat politically for taking that stand. And so, as time goes on, and I really am convinced that Alberta must leave Canada. I'm saying this publicly for the first time. On a balance of probabilities, that means 50% plus 1, I believe it is now probable that at some point Alberta will leave Canada. Canada is weakening, is under severe debt. The European Union is crumbling. The world is changing. And for safety reasons, Alberta must leave Canada. So that took me to the place of Alberta Unfiltered and explaining to the general public how my goal is one of many, to explain the how of Alberta can leave Canada, because it is doable. It just takes a lot of work and a lot of thought.
All right. Well, let's see if we can't move a little more direct into the process.
Okay.
Now, for the purpose of this conversation, I thought I had two antagonists, pleasantly, on the issue. And what I need to tell Tim and Marilyn is I actually have found out you guys are coming at it on the exact same page from different sides, which surprised me. But for our viewers, I'm going to see if I can help out with this process. So if I do the whole, share the information thing, the Statute of Westminster was passed by the British Parliament in 1931. It's one of our most important constitutional documents in the history of Canada and other nations that were once part of the British Empire. It marked a turning point in the evolution of those countries from colonies under the British control to fully self-governing nations by themselves within what became known as the Commonwealth of Nations. Now, before the statute, even though countries like Canada, Australia, and New Zealand had their own parliaments and governments, the British Parliament still had legal authority to make laws for them. Now, this arrangement meant that their independence was more practical than legal. They could govern their daily affairs, but ultimate power rested in London. Now, the Statute of Westminster changed that. It recognized the equality of the self-governing dominions with the United Kingdom, giving them full control over their own laws and freeing them from British legislative interference. In essence, it declared no act of the British Parliament would apply to these dominions unless they chose to accept them. Now, for Canada, the statute was a defining milestone on the path to a full sovereignty. It allowed Canada to act independent in international affairs and laid the groundwork for complete constitutional independence, a process that would later accumulate in the patriation of the Constitution in 1982. In simple terms, the Statute of Westminster was the moment when countries like Canada stopped being children of the empire and became equal partners in a family of nations. It didn't create independence overnight, but it gave the legal foundation for the freedom that Canada and others now enjoy. Now, that's the basics that have been promoted about the Statute of Westminster. So now let's take us into the first part of our supposed debate. If we were to look at what the Statute of Westminster means, I'm going to start with Tim, and Marilyn, you'll get an opportunity to either add or voice a contrary opinion. Tim, can you tell us what the Statute of Westminster means from your research?
Yes. And I'll only focus on 3 sections that actually are applicable to Canada and are meaningful in that sense. That is Section 2, Section 7, and Section 11. Section 2 is pretty straightforward. It says that the Colonial Laws Validity Act shall no longer apply. So Colonial Laws Validity Act is removed, meaning you're not treated as a colony anymore in basic terms. In Section 11, there's a severing occurs between the term dominion and colony. And the important word in Section 11 is notwithstanding. That means it overrides whatever comes after notwithstanding. And it says, notwithstanding what is mentioned in the Interpretation Act from 1889. That Interpretation Act very clearly, very precisely defined a dominion to be a colony. And also a province of a dominion to be a colony. So Section 11 said, we don't care what's mentioned in that act. From this day on, after the Statute of Westminster is passed, no dominion shall be considered a colony any longer, and no province of a dominion shall be considered a colony any longer. Then in Section 7, it stated that the principles of Section 2, removing colonial law, also applies to any province or state that forms part of a dominion. So this was to ensure that once the Dominion of Canada ceases to exist, which was a united colony, you would still have the single independent colonies that we now call provinces. And Section 7, subsection 2 made sure that these single colonies also were not under colonial laws any further. Section 7, subsection 1 is the big part that causes a lot of confusion because it attempts to exclude the BNA Act from the Statute of Westminster. And to understand really that, based on my research, that subsection can be completely disregarded, is the fact that the BNA Act was never a constitution, because it constitutes absolutely nothing. In it, it states that it is an instrument to aid and advise the Governor General in the government. And why the BNA Act was never a constitution, because the constitution of executive government was actually already constituted in 1763 with letters patent to Governor James Murray for the province of Quebec. So once you unite that province with more provinces into a united colony, I shouldn't have said province, I said colony, but it was a colony, the province of Quebec. Once you unite that into one colony, where you already had a government that was constituted for one colony. You can't have two central governments. So the BNA Act from 1867 was simply an instrument to extend the power that was granted to one Governor General in 1763, now to the United Colony, still under the same Governor General. So a Governor General, you can only have executive government if you have title to the land. That's part of that goes hand in hand with sovereignty. If you don't have title to the land, you can't march in and say, I'm now establishing executive government. So the two go hand in hand. When in Section 11, all of a sudden, the dominion and the term colony are disconnected, then what happens? The colony is not a colony any longer, then it becomes a sovereign state. Because there's no intermediate status. It's either a sovereign state or a colony. So when you claim that you don't claim this colony anymore, you also don't have title to the land anymore. If you don't have title to the land, you cannot appoint a Governor General. And the BNA Act could only be used by a Governor General, not by anyone else. So that is the conclusion why subsection 1 of Section 7 can be disregarded, because it doesn't really apply. Now, it leaves the door open that if someone wanted to use the BNA Act, you could probably ask the UK Parliament for permission. Hey, can we use the BNA Act to establish our own lawful government? And they would probably say, sure, go ahead, use it, but it is not binding.
Okay. So, Marilyn, you're shaking your head. I take it
No,
that...
that's gibberish.
Okay. Can you explain, please?
Yes. So first of all, respectfully, Kirk, I'm going to disagree with you in that the Statute of Westminster had anything to do with being self-governing, okay? That was not the purpose of the British North American Act, with the exception, self-governance in a limited capacity, to make laws and not be bound by the laws of Britain. However, I absolutely and fundamentally disagree with Tim, okay? When we get to Section 7.1, and I really would urge people to read this. It's not a complicated document. It's a simple document, and it's very, very important. 7.1. Nothing in this act, nothing, shall be deemed to apply to the repeal, amendment, or alteration of the British North American Acts 1867 to 1930, or any order, rule, or regulation made thereunder. This was the Constitution of Canada, and it remained the Constitution of Canada until Pierre Trudeau crafted, basically repatriated Canada's Constitution, renamed it the Constitution Act. It was a renaming. Queen Elizabeth signed it, which I think was her fatal error. So the Constitution, being the British North American Act, stood. And this is where Tim and I are fundamentally going to disagree, because he goes down all kinds of twists and turns that I'm going to say has been so dangerous to Albertans.
Marilyn, why? Why is it so dangerous?
There is a process set out in the Constitution Act, a process. Processes are important. In order to bring Alberta to a safe place of independence, the British North American Act did not give Alberta sovereignty or Canada sovereignty from Britain. So good, ordinary, decent people are being misled by Tim and those who take all kinds of squiggles and wiggles that make no sense, so that people who could ordinarily make good decisions to take us towards independence are now being twirled up in circles, and they're all constantly being dropped off cliffs. So Section 7.1 is critical. Again, nothing in this act applies to the British North American Act, which was our Constitution. Subsection 2 of Section 7. This extends to laws made by any of the provinces, so provinces can make their own laws. And then further, the powers are, the Parliament of Canada has the powers. And specifically it says the Canadian government, federal government, can make laws within its jurisdiction. The provinces can make laws regarding their jurisdiction. We go to Section 91 to 96 of the Canadian Constitution, and this comes from the British North American Act. It's called the Division of Powers. The federal government has certain say over certain issues. The provincial government has certain say in certain issues, such as education goes to the provinces. So just reading on and going around and around in circles that nobody can understand, Tim, respectfully, you're confusing people. And for me, my purpose is to take Alberta out of Canada. It completely detracts good people in Alberta. Now, I agree with you that the word colony no longer applies. That is Section 11. We're not called a colony anymore. We're called a dominion. Whether that means equality of what, I'm not sure what you're meaning, Kirk. We're provinces within a country where we can make our own laws. And I want to take you back to the beginning. You made a comment about the king, Tim. And it's right at the very beginning. Whereas delegates to His Majesty's governments, the crown is a symbol of the free association of the British Commonwealth of Nations. So we're not free from the royal family. It's nice to think, and I think you might be correct, that Britain would allow Alberta to become its own nation. And it's certainly better for agreement than war, because war is murder and theft and subjugation. This Statute of Westminster was an agreement. And I think it was a good agreement for the time. But there's a lot of work left to do.
Okay. So if we move on from there, let me ask you a question. When Section 2, the secession clause of the BNA Act, was revoked by Queen Victoria in 1893, where did the ownership of the Dominion of Canada go when Victoria died in 1901?
I have no idea what you're talking about. I don't have that in front of me, and nobody told me it was going to come up. I can do the research if you like.
No, that's fine. It was just a curiosity to see if the pieces I'm trying to come up with. Tim, do you have a comment?
I can answer that.
Okay, please do.
Yeah. Removing that succession clause had absolutely no impact on the Dominion or on the BNA Act in terms of did it make the BNA Act die when Queen Victoria died? No. And what people need to understand is, and I think that's where Marilyn has some misunderstandings too, is that when any of these statutes, and this is since the 16th century, any of these statutes that refer to the Queen, the King, Her Majesty, His Majesty, are not referring to the human being, are not referring to them in a personal capacity, like the royal family. What it refers to is the Crown Office, a corporate soul, the office of the Crown. So whenever a statute says the King or the Queen, it refers to the office of the Crown. And I can quote you 6 court cases where that is confirmed. Solid court cases. So the BNA Act had nothing to do with Queen Victoria personally, unless the statute specifically says so, and it doesn't. So removing the succession clause had no influence on the BNA Act when she died, because A, it was never written for her. It was written for a Governor General, and it was written by the Crown Office. So when she died, the BNA Act simply continued on.
Okay. Well, I understand the subtleties that are being discussed, and I really do. And I appreciate the clarity. And this can be a great movement forward in making sure there's a clarity. But I'd really like to bring a concept more because both of you value the Statute of Westminster. What if you had your control, your magic wand right this second? And I'll start with you, Marilyn. Instead of the path we're on and that's being promoted, and Tim, you'll have a chance to respond, where do we go next? What do you see as being the next step for us to take if the statute is got a value?
Well, I don't understand your question at all. The statute has a value because it gave the provinces in Canada the right to make laws under sections 91 to 96 of the federal constitution. Okay.
Yeah.
So nothing Tim says makes sense to me whatsoever. And I have tried to listen to some of these Statute of Westminster types. They make no sense and they add no value whatsoever to Alberta becoming its own nation. So where we go forward, I'm explaining it on Alberta Unfiltered. The process of the Constitution Act of Canada, of course, was not signed by Quebec. That's a different legal question, the validity of that constitution. However, we are where we are. We don't always like our realities. There have been successive referendums. Referendums only form part of the necessary steps. So I'm looking forward. I see absolutely zero value in what Tim is promoting.
What about the other groups like, I'll say, Alberta Prosperity Project or any of the other separation groups using the Statute of Westminster as a stepping stone to their end goals? Is this the tool
I would very much doubt the Alberta Prosperity Project cares anything about this Statute of Westminster as described by Tim. They're very focused on the referendum and referendum aspect, and I don't think they get all twirled up about the Statute of Westminster.
Perfect. Tim, do you see any value of any of the other groups moving forward using the statute?
If any group is explicitly using the statute, then yes. Anyone who promotes referendum and using the Clarity Act, absolutely not. And I wish those people would actually read the Clarity Act and would see how in at least 6 or 7 sections it completely sets up a failure of any referendum, because it is not something that the people have control over. Everything is controlled by the government, and the outcome is highly unlikely. It's designed to fail, and it's designed to take many, many years. And the way I see it, it's simply a distraction. If people read the Statute of Westminster, and I must say at this point, I don't like the language Marilyn is using in an attacking fashion to try and discredit what we've been trying to say and what we try people to get them to do and read. Just by repeating Section 7 and subsection 1 doesn't make it any more true or valid, just if you repeat it 700 times in a row. If you don't understand the underlying concept of land ownership and what Section 2, 7, and 11 combined achieved, then you will get caught in a vicious cycle of looking at Section 7 and thinking that you're still at the mercy of a BNA Act, which cannot be referred to as a constitution because it never was a constitution. Maybe the UK Parliament decided to rename it the Constitution Act, but it doesn't make it a constitution just because it was called that. And just to be precise, the Constitution Act 1982 is part of the Canada Act 1982. The Canada Act 1982 is an act of the UK Parliament. So, if Section 11 ensures that the Dominion of Canada is not a colony any longer, then it's a sovereign state. How come a foreign country enacts an act in 1982 that would then set Canada free? That makes absolutely no sense.
Okay. So, based on, from what I've heard, both of you are agreeing there's a strength of the statute. Where do you think moving forward the use of the statute needs to go? Tim?
Well, I think people need to read it, and not just read it, but understand it in connection to the other documents of reference and in connection to type who and what is the crown, who or what is the king or queen, and then look at what really transpires as the outcome of the statute since 1931. Really, it has, and that has been established in official documents. There's a deposition between a King's Counsel and Russell Roger Smith that's documented in official archives, 1944, where all of this is described. It has been brought into the Canadian Parliament a few times. The issue that each province has been left in a state since 1931 where the province first has to write a constitution and seat a lawful government. And then they can discuss a federation of all provinces. But that still has not happened to this day. So instead of fighting against a corporate institution called government that makes a law that is based on a Supreme Court opinion, not even a ruling, an opinion. And in that law, in that act, it's not a law, it's an act, it's a statute. They describe how they are in control of any possible succession. It just makes no sense when, on the other hand, you have the statute with the underlying concept of here's what we actually just need to do. And how come the Irish Free State has been able to do that based on the Statute of Westminster?
Okay, for those of us who are not as nearly as educated as you folks are, in the statute, is there anything to do with land ownership that's been brought forward?
No.
Thank you. That's an easy answer. I like it. Simple. How about Queen Victoria, did that have anything
No,
to do? No, thank you very
no.
much. Answers that one as well too. Marilyn, I love talking to you. It makes things really easy when I'm trying to figure out how to progress the next comment. So Marilyn, what do you want to see happen next? I mean, quite frankly, you have presented to me that you see an absolute value in the statute. It's a wonderful tool for the separation or the independence of Alberta. What's the messaging you need to go through with? This is a
I've
great
never
question.
said that. Sorry, Kirk. I've never said it's a tool for Alberta independence. Okay, I've never said it's a tool. It is part of the history of the path. I am going to agree with Tim on one thing, and that is the Clarity Act is clear as mud, and the process of the path to Alberta's independence needs to be brought back before the Supreme Court of Canada, because I do not believe the Chrétien government followed the directions of the Supreme Court in the Quebec 1995 reference decision. So that's one of the aspects. So, and I do honestly want to say, with the greatest of respect, what I hear from Tim is not helpful in any way. So, but there are other matters also that are not helpful, and that is, for example, the 51st state. There are diversions. We saw with Peter Downing, the twisting people up in circles and dropping them off cliffs. So my goal always as a litigator was to present answers to judges at a grade 5 level, because they only got to hear it once. So to your viewers, Kirk, the path forward is referendums definitely do matter. The Supreme Court of Canada said that, but it does not end there. And Tim and I could agree with that, because there are concepts of federalism. If you follow through the Alberta Unfiltered channel, the Supreme Court is not only bound by federalism, it's bound by First Nations rights, which are, a significant factor. All of these reasons, to leave Canada all have to be taken into consideration and dealt with fairly. So the process for me going forward is not to twist myself up in circles about the Statute of Westminster that leads to no practical solution whatsoever.
Okay. And Tim?
Well, I would say that Marilyn's argument will certainly make sure that people remain in a corporate construct that does not give them the liberty that they're seeking. And I think you asked a question about land ownership, and I have to say that the Statute of Westminster indirectly addresses land ownership.
Okay, can you clarify that a bit, Tim?
Yeah, Section 11. It severs the connection between a dominion and a colony. If you have a colony, you own it, and you send a governor general to be a dictator. If you dispose of that colony, what does the colony then become? If you say, I don't want it anymore, you can have it. What is it then? What is that landmass? If it's not a colony, it is a sovereign state. Right?
Yeah, it's definitely not a sovereign state. The country of India gained its independence. The country of Burma gained its independence. They became sovereign states by becoming sovereign countries.
If you're not a colony, what are you?
Under the Statute of Westminster, you're a dominion.
No. In general, I'm not talking under the Statute of Westminster. In general terms, if you're not a colony, what are you?
That's a ridiculous question, quite honestly. In
Why is that
general
ridiculous?
terms, it's different. We specifically have in front of us the Statute of Westminster. Okay, I'm reading it right here. It specifically says, and I'm going to read it out loud for the viewers. The expression colony shall not, after the commencement of this act, include a dominion or any province or state forming part of a dominion, as it relates to the Statute of Westminster and Canada and these other countries We are a dominion. So we're not talking general terms here. We're talking about Canada as it relates to the Statute of Westminster. You do all kinds of theoretical wind-up things. They're not practical, and they
Okay,
don't lend to
thank you, Marilyn.
independence.
You're diverting the original question. The Dominion of Canada. What was the Dominion of Canada? Was that a colony or was it a sovereign country?
Neither.
How is the Dominion of Canada not a colony?
The Dominion of Canada is not a colony because it specifically states that in the Statute of Westminster, as I've read and you've read.
No, it does
It does
not.
not say, yes, it does. Absolutely does. Black and white.
Where does it state in there that the Dominion of Canada is not a colony? That's what you just claimed.
We've read it a number of times, Tim.
No, please tell me. Where does it state?
In this expression, dominion means any of the following dominions. This is section 1. The Dominion of Canada, the Commonwealth of Australia, the Dominion of New Zealand, the Union of South Africa, the Irish Free State, and Newfoundland. Dominion is defined. There is a specific definition of the word dominion in section 1 as it relates to these entities.
And how is the 1889 Interpretation Act, how does that define a dominion?
I believe what you're saying, and your question is confusing. Section 1 defines, it's the definition section of dominion, okay? And then we go to the very end, because this act only has 12 parts, section 11, notwithstanding anything in the Interpretation Act, the expression colony shall not, after this act is passed, include a dominion or any province or state forming part of a dominion. So colony doesn't apply anymore. Because of the Statute of Westminster, Canada is a dominion, no longer a colony, and that has never changed. And here's why I fundamentally disagree with Danielle Smith. She is redefining the word sovereignty. There is nothing that is ever given Alberta sovereignty or Canada from the British Crown.
Yes, it has. And I find it interesting because you quote in the beginning that it's defined as a dominion, but then you go to section 11 and say a dominion is not a colony anymore. So the Dominion of Canada, that's what it was called. The Dominion of Canada is then not a colony anymore. So
Correct.
with the Interpretation Act from 1889, a dominion is not a colony anymore. So we cannot be a dominion anymore at the same time when the dominion is not a colony anymore.
Okay, it says the Interpretation Act does not apply. That's what section 11 specifically says. Notwithstanding anything in the Interpretation Act, get the Interpretation Act off the table. It doesn't matter in the context of the Statute of Westminster.
No, it says notwithstanding anything defined in it.
No, it doesn't say that. It doesn't say that. Those are not the words. Notwithstanding anything in the Interpretation Act.
Yeah, that's what I just said. Notwithstanding anything.
No, you said you put the word defined in there. It does not say notwithstanding anything defined in the Interpretation Act. It says notwithstanding anything in the Interpretation Act.
And I don't think that is the big difference that you're trying to use to derail my argument, just because the word defined is not stated in there. It is clear that it says notwithstanding anything.
But I think one of the things that's missing is that, and I'm not in your level of expertise at all. If it's missing, then it's not there. That's just my call on it.
Nothing's missing.
How it's interpreted as if the word was missing may be the hole or the hole in the argument, if you will.
So, Marilyn, you claim that the Dominion of Canada was not a colony.
I never said that. That's the opposite of what I said.
That's what you said 5 minutes ago.
I did not. I've never said that. I said the Dominion of Canada was a colony. The Statute of Westminster says Canada is no longer a colony. It's now a dominion, as well as all these other countries.
Then what is a dominion?
Dominion means any of the following dominions under the Interpretation Act. You can decide any other definition you want in any other context. You can say dominion means a shellfish in the ocean. I don't care. But in this act, the Statute of Westminster, dominion means the following entities: Canada, Australia, New Zealand, South Africa, Irish, Free State, Newfoundland. Those are the dominions, the specifically defined dominions as it relates to this act. You can say, oh, in general, it means a fish in the ocean. I don't care. But in this act, dominion means these specific countries. Well, we call them countries, but they're dominions.
So then after the passing of the statute, it simply says that those dominions are not colonies of Great Britain any longer, correct?
Correct.
So you can still call it a dominion. However, when you look at section 7, subsection 2, that grants each province that colonial laws do not apply anymore.
It doesn't say that. When it comes to colonial laws, and that's a section 2, as you've indicated, colonial laws shall not apply to any law after the commencement of this act by the Parliament of a Dominion. So the colonial laws don't apply anymore.
Yeah, that's what I just said.
Heard, yes, so we're agreeing on that one. I've also heard people say, and this is more the common law type group, where we have to get rid of the Merchant Shipping Act. We have to get rid of the Admiralty Act. The Statute of Westminster did this. So this Statute of Westminster, it's very significant in Canada getting the heck out of, Alberta getting the heck out of Canada.
So you say the Dominion of Canada was a colony. It was not an independent.
That's what it says. Correct.
No, that's what you're saying.
Yes, that's what the act says.
Well, the Dominion.
And that's history too.
Okay, let me finish my question, please. The Dominion of Canada was a colony. It was not an independent country. So why would we have why would we have something called confederation when it was a colony? Can you explain that? Like how can we define something as confederation that happened in 1867 when it clearly wasn't, because colonies can't confederate, only sovereign states can do so?
Who says that colonies can't confederate?
How can colonies confederate when colonies do not have the ability to govern themselves?
They had limited ability to govern themselves. Of course, the British way of doing things was to appoint one person, the Governor Generals. Very quickly, though, the practice was that the word provinces was being used. And I don't know where the term province was originated. It doesn't matter in this context. So, I mean, getting into all these little twists and turns that don't make any difference.
They do
It's a
make
distraction.
a difference. That's exactly
No, they don't.
what we need to do. No, the distraction is repeating one subsection and saying that it's all gibberish. That is the distraction. Because what really matters
No,
is
I didn't say the subsection was a gibberish. I said what you're claiming is gibberish.
Yes, and I'm not interrupting you, so please let me finish. You talk in a sense that you call it gibberish, you're trying to discredit it. But what's really important is that we actually go through these little details, that we determine what is land ownership really based on? Who owned the land of the colonies, and how was the land given up? And then what happened? What happened to when land is given up? You're completely disregarding that as gibberish that derails an independence movement, but you're just repeating something of a BNA Act that in fact doesn't really apply anymore. So we're not getting anywhere if we just try to hack into each other's arguments and try to repeat the same arguments without giving any credit or having an open mind to, okay, let's look at this.
Okay, well, on that note, I'd like to actually move forward with this from a different perspective. First off, I think it's fair to say that the passion behind each perspective is obviously why you guys were invited. Not just the passion, but the knowledge that you have. I would like to kind of move this towards a wrap up, and I'll start with you, Marilyn. You've come out and said, you know, there's a whole lot of word twisting and stuff going on behind the scenes, and you wish people would just get on track. And I'm paraphrasing, it's not exactly, I understand. But if I was to say, can you give us 5 minutes of just what do you want to see out of this? You have a YouTube channel as well, and I'd like you to tell people where they can get some more information about, at least from your perspective. But take 4 or 5 minutes and kind of wrap up where you really want this to go.
Thank you, Kirk. You invited me to talk about what I consider to be relevant to the Statute of Westminster because I did a YouTube video on this, on Alberta Unfiltered. So if you Google just basically YouTube and then there's search Alberta Unfiltered, my purpose is not only to explain how Alberta can leave Canada, because it can. There are a lot of other topics I intend to put on Alberta Unfiltered, and I've touched on them. One is history of Alberta, why Alberta joined Confederation at all. I want to get into health. I want to get into mental health also. And I'm going to do a segment on the Book of Revelation because I'm going to state this very clearly. I have not met anyone on this planet yet who knows Revelation anywhere near as well as I do. And I'm going to present the facts of what Revelation says, not my interpretation. So that's the whole point of Alberta Unfiltered. Going forward, though, I do want to lay out the very specific processes, and I'm going to underscore the word processes, necessary to be done for how Alberta can leave Canada, because it is vital that we do.
Please do. And they'll see on Alberta Unfiltered?
Yes.
Fantastic. Thank you very much. Tim, it's not over. There's more to go. Can you take a couple minutes and go through how you see this actually moving in the direction you're hoping for?
Yeah, certainly. It only happens when people read the documents and not trust corporate entities with achieving something that they want to achieve, because by now people should have seen that corporate entities will guide them down a road that leads to the corporate entities winning and the people being slaves. Time again has shown this to be true. So for this to lead anywhere, it has been expressed by several people before me that Alberta, just like every other province and territory, left Canada on December 11, 1931. That has not been realized by the people. There are numerous documents that show that fraud has been committed since. One of them being the Governor General's website in 2001, even stating that the Governor General is a de facto head of state. Other documents court cases, even books written by judges that state what the facts were before 1931 and after 1931. So people need to realize that they don't need to ask a politician or a corporate solicitor or the crown for any permission to do something that they've had the right to do since 1931. If they don't want to do it, that's fine. But they need to realize that they have the power to simply declare it. That's what Ireland did.
All right. Tim, want to say thank you very much. People want some more information from your perspective. Where do they go?
They can go to CanadaIllusionFilm.com. There are links to YouTube, Rumble, Twitter, and Telegram. They can also email me at canadaillusion@proton.me. I don't charge any money for any of this. I happily share the information. I show people where to find it. I don't just tell them, believe me. I tell them, look, read, go read. If you find something to contradict it, show me. But really do the reading. But yeah, go to the website. On X, you can contact me as well. Read the exposure of the Clarity Act. That's how you can get in touch with me.
Tim, thank you very much. Marilyn, I want to say thank you very much for participating today. To our viewers, we've got another guest coming on in just a couple minutes' time. Stay with. We will be back in just a few minutes. But to Tim and Marilyn, thank you very much for your time today. Hopefully we can have you on.
Thank you for hosting this, Kurt. Appreciate it.
No problem. Thanks, guys.
Awesome, guys.
Don't go anywhere. We'll be right back.